Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Stanley v. City of Sanford. In this case, the court considered this issue. Under the Americans with Disabilities Act, does a former employee, who was qualified to perform her job and who earned post-employment benefits while employed, lose her right to sue over discrimination with respect to those benefits solely because she no longer holds her job? The case was decided on June 20, 2025. The Supreme Court held that the Americans with Disabilities Act does not protect former employees who neither hold nor desire a job at the time of an employer's alleged act of discrimination. Justice Neil Gorsuch authored the majority opinion of the court. Title I of the ADA makes it unlawful for employers to discriminate against a qualified individual based on disability regarding compensation and other employment matters. The statute defines a qualified individual as someone who can perform the essential functions of the employment position that such individual holds or desires. The present tense verbs, holds, desires, and can perform signal that the law protects individuals able to perform a job they currently hold or seek when discrimination occurs, not retirees who neither hold nor desire employment. The statute's definition of reasonable accommodation, which includes job restructuring and modifying facilities for employees, reinforces this interpretation by referencing accommodations that make sense only for current employees or job applicants, not retirees. The ADA's structure further supports this reading through its examples of discrimination in Section 12112B, such as qualification standards and employment tests, which clearly aim to protect job holders and seekers rather than retirees. Additionally, comparing Title I with Title VII of the Civil Rights Act reveals that while Title VII protects employees without temporal qualification, the ADA's use of qualified individual linked to present tense verbs indicates protection for current job holders or seekers only. The court's precedent in Cleveland v. Policy Management Systems Corporation anticipated that someone may fall outside the ADA's protections if she can no longer perform the job. Justice Clarence Thomas authored an opinion concurring in part and concurring in the judgment, joined by Justice Amy Coney Barrett, expressing concern about litigants changing their arguments after the court grants certiorari. Justice Sonia Sotomayor authored an opinion concurring in part and dissenting in part, arguing that Title I's prohibition on disability discrimination should not cease when an employee retires. Justice Ketanji Brown Jackson authored a dissenting opinion, joined by Justice Sotomayor in parts, arguing that the majority misreads Title I by viewing it through the distorted lens of pure textualism, incorrectly using the qualified individual definition as a temporal limit it was never designed to be, and thereby rendering meaningless the ADA's protections for disabled workers' retirement benefits just when those protections matter most. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Gorsuch announced the judgment of the court and delivered the opinion of the court with respect to Parts 1 and 2, and an opinion with respect to Part 3, in which Justice Alito, Justice Sotomayor, and Justice Kagan join. Title I of the Americans with Disabilities Act bars employers from discriminating against a qualified individual on the basis of disability in regard to compensation and other matters. The statute defines a qualified individual as an individual who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. The question before us concerns whether a retired employee who does not hold or seek a job is a qualified individual. Because this case comes to us on a motion to dismiss, we take as true the well-pleaded facts in the plaintiff's complaint, National Rifle Association of America v. Vullo, and do not consider evidence beyond that pleading, Carter v. Stanton. With those constraints in mind, we begin by setting out the facts as the plaintiff, Karen Stanley, has alleged them. Ms. Stanley started working as a firefighter for the city of Sanford, Florida, City, in 1999. At first, she planned to serve for 25 years. Part of the reason for that had to do with health insurance. At the time the city hired her, it offered health insurance until age 65 for two categories of retirees, those who retired with 25 years of service, and those who retired earlier because of a disability. In 2003, though, the city changed its policy. Going forward, it said, it would continue to pay for health insurance up to age 65 for retirees with 25 years of service. But for those who retired earlier due to disability, the city announced, it would now provide health insurance for just 24 months, unless the retiree started receiving Medicare benefits sooner. At some point after the city revised its policy, Ms. Stanley's complaint does not say when, she began to suffer from an unspecified disability. And, in 2018, that disability forced her to retire earlier than she had planned. Under the city's revised policy, that meant she was entitled to at most 24 months of health insurance. Based on these facts, Ms. Stanley brought suit claiming that the city had violated the ADA and a number of other state and federal laws, providing different health insurance benefits to those who retire with 25 years of service and those who retire earlier due to disability. She contended, amounted to impermissible discrimination based on disability. The city responded by filing a motion to dismiss Ms. Stanley's complaint for failure to state a claim. The district court denied that motion in part, allowing some of Ms. Stanley's claims to proceed. But with respect to her ADA claim, the district court saw things differently. Ms. Stanley's complaint, the court observed, alleged that the city had treated her worse than other similarly situated individuals because of her disability, what is known as a disparate treatment claim, Raytheon Company v. Hernandez. To state such a claim under the ADA, the court continued, Ms. Stanley was required to allege, among other things, facts sufficient to show that she was a qualified individual at the time of the city's alleged discrimination. But in this case, the court reasoned, the discrimination Ms. Stanley alleged, reduced healthcare benefits, did not take place until after she retired. And by that point, she was not a qualified individual under the ADA because she was not someone who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. As a result, the court held, it had no choice but to grant the city's motion to dismiss her ADA claim. The 11th Circuit affirmed. It, too, concluded that the ADA does not reach allegations of discrimination against a retiree who does not hold or desire to hold an employment position that she is capable of performing with reasonable accommodation. But, the court acknowledged, not every court of appeals would agree. Like the 11th Circuit, the 6th, 7th, and 9th Circuits have said that Title I's anti-discrimination provision does not protect people who neither held nor desired a job with the defendant at the time of discrimination. But the 2nd and 3rd Circuits take a different view. As those courts see it, the ADA's definition of qualified individual is ambiguous, and they have resolved that ambiguity in favor of extending the statute to reach retirees like Ms. Stanley. We granted certiorari to resolve the circuit's disagreement over whether the ADA reaches discrimination against retirees who neither hold nor desire a job whose essential tasks they can perform with reasonable accommodation. The ADA contains 5 titles separately addressing employment, public entities, public accommodations, telecommunications, and miscellaneous matters. Ms. Stanley brought her suit under Title I, which speaks to employment. The ADA provides Title I's general liability rule for disability discrimination. It makes it unlawful for a covered employer to discriminate against a qualified individual on the basis of disability in regard to compensation, among other things. The parties disagree about the meaning of this language, but their dispute is a narrow one. They take as given that retirement benefits, like those at issue here, qualify as compensation, Hishin v. King and Spalding, Newport News Shipbuilding and Drydock Company v. EOC. For purposes of our review, we may also assume that the city's revision to its retirement benefits plan constituted discrimination on the basis of disability. The only question that separates the parties is whether the ADA addresses discrimination against retirees like Ms. Stanley. She, and 2 circuits, think the answer is yes. The city, and several other circuits, believe otherwise. To resolve that disagreement, we turn, as we must, to the statutory terms Congress has given us. The ADA tells us that Title I prohibits discrimination against qualified individuals. And a qualified individual, Title I continues, is someone who, with or without reasonable accommodation, can perform the essential functions of the employment position that she holds or desires. From these directions, one clue emerges immediately. To ascertain a statute's temporal reach, this court has frequently looked to Congress' choice of verb tense, Carr v. United States. And here, Congress has made it unlawful to discriminate against someone who can perform the essential functions of the job she holds or desires. Those present tense verbs signal that the ADA protects individuals who, with or without reasonable accommodation, are able to do the job they hold or seek at the time they suffer discrimination. Conversely, those verbs tend to suggest that the statute does not reach retirees who neither hold nor desire a job at the time of an alleged act of discrimination. Reinforcing this assessment is the statute's definition of reasonable accommodation. Title I, recall, prohibits discrimination against an individual who can perform essential job functions with or without reasonable accommodation. And a reasonable accommodation, the ADA provides, refers to things like job restructuring, modifying existing facilities used by employees, and altering training materials or policies. Those kinds of accommodations make perfect sense when it comes to current employees or applicants. But it is hard to see how they might apply to retirees who do not hold or seek a job. The ADA conveys a similar message. That provision offers examples of what constitutes discrimination against a qualified individual on the basis of disability. So, for instance, the ADA defines discrimination to include using certain qualification standards, employment tests or other selection criteria unless they are job-related for the position in question. Plainly, that mandate aims to protect job seekers, but it makes no sense in the context of retirees who do not seek employment. The same goes for the ADA, which requires that tests concerning employment accurately reflect the skills and aptitude of an employee or applicant. It would be strange for employers to test the job skills of former employees who do not plan to return to work. This pattern repeats itself throughout the ADA, underscoring the ADA's focus on current and prospective employees, not retirees. Instructive, too, is the fact that another part of the statute speaks differently. Where the ADA prohibits certain acts of employment discrimination against a qualified individual, the ADA prohibits retaliation against any individual who opposes a discriminatory act. That Congress used different language in these two provisions strongly suggests that it meant for them to work differently. After all, when a document uses a term in one place and a materially different term in another, the presumption is that the different term denotes a different idea. Southwest Airlines Company v. Saxon. Further evidence still comes from examining Title I of the ADA in light of Title VII of the Civil Rights Act of 1964. The two statutes share much in common, not least the fact that they both address employment discrimination, Mount Lemon Fire Dist. V. Guido. But the statutes also bear differences we have found illuminating in the past, EEOC v. Abercrombie and Fitch Stores Incorporated, and one difference concerns the class of people the statutes protect. Title VII protects employees, a term that law defines without any temporal qualifier, Robinson v. Shell Oil Company. In keeping with that unqualified term, Title VII sometimes bars discrimination against former employees as well as current ones. But elsewhere in Title VII, context clarifies that the term employee refers unambiguously to a current employee. That is true, for instance, where the statute links the term employee to present tense verbs like work and has. The upshot? Even if the ADA's reference to a qualified individual, like Title VII's reference to an employee, might be read in isolation to encompass retirees, once Congress yokes those kinds of terms to present tense verbs, such as holds, desires, and can perform, that assumption becomes considerably less plausible. Beyond all this textual evidence lies our precedent. Construing an earlier version of Title I in Cleveland v. Policy Management Systems Corporation, this court explained that an ADA plaintiff bears the burden of proving that she is a qualified individual with a disability, that is, a person who, with or without reasonable accommodation, can perform the essential functions of her job. Accordingly, the court concluded, a plaintiff's sworn assertion that she is unable to work will appear to negate an essential element of her ADA case. In saying as much, the court anticipated the possibility that someone may fall outside the protections of the ADA if she can no longer do the job. Albertsons Incorporated v. Kirkingberg. Against this evidence of statutory meaning, Ms. Stanley and the dissent offer several replies. They begin by suggesting that we should interpret the ADA's qualified individual requirement as imposing only a conditional mandate. As Ms. Stanley and the dissent see it, if a plaintiff claims discrimination with respect to a job she seeks or holds, then she must show that she is able to perform that job's essential functions. But if the plaintiff neither holds nor desires a job, the argument goes, then she must make no such showing. In that case, the plaintiff is necessarily a qualified individual, because it is impossible for someone to be unqualified for a non-existent position. Through this series of steps, we are asked to conclude, every retiree is a qualified individual. As easy as it may be to imagine a statute like the one Ms. Stanley and the dissent outline, it bears scant resemblance to the one Congress enacted. Title I might have said, for example, that a qualified individual is one who can perform the essential functions of the employment position, if any, that such individual holds or desires. But nothing like that italicized language appears in the ADA. And even supposing Ms. Stanley's conditional mandate theory were a textually permissible way to understand the statute, we do not usually pick a conceivable but convoluted interpretation over the ordinary one, Wisconsin Central Limited v. United States. Separately, Ms. Stanley attempts a surplusage argument. She contends that our interpretation of qualified individual would render meaningless part of the ADA, which defines discrimination to include the failure to reasonably accommodate an otherwise qualified individual with a disability who is an applicant or employee. After all, Ms. Stanley suggests, if every qualified individual holds or desires a job, then the ADA's reference to applicant or employee performs no real work. To avoid that outcome, she submits, the class of qualified individuals must include retirees. Difficulties attend this argument as well. To start, our reading of qualified individual may still leave work for applicant or employee to perform in the ADA. It might be, for example, that the phrase applicant or employee narrows the provision, so that it does not refer to a non-applicant who desires but does not apply for a job. Duvall v. Webb, Dougherty v. El Paso. But even if the phrase applicant or employee is redundant, serving only to underscore that the ADA extends beyond existing employees to those seeking work, the canon against surplusage is not an absolute rule, Marks v. General Revenue Corporation, and it certainly does not require us to favor an unusual meaning that will avoid surplusage over a more natural one. Perhaps sensing that Title I's definition of qualified individual goes against them, Ms. Stanley and the dissent next effectively ask us to strike it from the statute. As they point out, Title I allows any person alleging discrimination on the basis of disability to sue, and a plaintiff may file that suit whenever she is affected by discrimination. Finally, such suits can challenge discriminatory compensation. Putting this all together, Ms. Stanley and the dissent reason, this case checks all the boxes. Ms. Stanley is a person suing about discriminatory compensation that affected her during retirement. And that is all Title I requires, making the qualified individual language largely beside the point. This argument misapprehends the nature of Title I's protections. It may be that retirement benefits are compensation protected by the Act. No one before us disputes that point. But the ADA does not protect compensation as such. Instead, it bars employers from discriminating against a qualified individual on the basis of disability in regard to compensation. In other words, the statute protects people, not benefits, from discrimination. And the statute also tells us who those people are: qualified individuals, those who hold or seek a job at the time of the defendant's alleged discrimination. So rather than resolve anything, this argument takes us right back to where we started. Failing all else, Ms. Stanley and the dissent ask us to look beyond text and precedent. Finding pure textualism insufficiently pliable to secure the result they seek, they invoke the statute's primary purpose and legislative history. As they see it, the ADA's goal of eradicating disability-based discrimination would be best served by a decision extending Title I's protections beyond those who hold or seek a job to retirees. But this submission falters too. For one thing, and as this court has emphasized many times, what Congress possibly expected matters much less than what it certainly enacted. Patel v. Garland. Nobody disputes the ADA's stated ambition to root out discrimination against individuals with disabilities. But it is quite mistaken to assume that any interpretation of a law that does more to advance a statute's putative goal must be the law. Luna Perez v. Sturgis Public Schools. Legislation is, after all, the art of compromise, the limitations expressed in statutory terms, often the price of passage, and no statute yet known pursues its stated purpose at all costs. Henson v. Santander Consumer USA Incorporated. Accordingly, this court has long recognized that the textual limitations upon a law's scope must be understood as no less a part of its purpose than its substantive authorizations. Kukana v. Holder. For another, we cannot say Title I's textual limitations necessarily clash with the ADA's broader purposes. One court of appeals, for example, has predicted that judicial innovations extending the ADA's protections to retirees might create perverse incentives by encouraging employers to reduce retirement healthcare benefits for people with disabilities. Morgan v. Joint Admin. BD. Retirement Plan of Pillsbury Company and AFL-CIO CLC. See how that dynamic might play out in this case. The 24-month health insurance benefit at issue here bridges the typical gap between disability retirement and the start of Medicare eligibility. Becerra v. Empire Health Foundation, for Valley Hospital Medical Center. Responding to a decision holding that the ADA addresses discrimination against retirees, the city might simply delete any reference to disability from its retirement policy to ensure that it contains no disability-based distinction. The result? Anyone who served 25 years would get subsidized health insurance. Everyone else, regardless of disability, would get nothing. Whether adopting Ms. Stanley's and the dissent's view of the statute would encourage outcomes like that is anyone's guess. But the possibility underscores why Congress's decision to limit the scope of Title I's anti-discrimination provision is not necessarily at war with the ADA's broader aims. Nor, of course, do the law's present limitations preclude future legislation from going further. If Congress wishes to extend Title I to reach retirees like Ms. Stanley, it can. But the decision whether to do so lies with that body, not this one. National Pork Producers Council v. Ross. For another thing yet, other avenues may exist for retirees like Ms. Stanley to seek relief, as her own complaint suggests, but the dissent neglects, a variety of other laws besides Title I of the ADA may protect retirees from discrimination with respect to post-employment benefits, including state law and the Rehabilitation Act, and an equal protection claim, Ware v. 20th Century Fox Film Corporation. As we discuss below too, even Title I, with its qualified individual limitation, may reach many claims involving discrimination with respect to retirement benefits. We took this case to resolve a circuit split over whether a retired employee who does not hold or seek a job is a qualified individual under Title I. In her merits briefing, Ms. Stanley invites us to address not just that question but another one too. Even if the ADA protects only those who hold or seek a job when a challenged act of discrimination occurs, she says, we should decide whether her complaint satisfies that standard. The government, as amicus, joins in this request. Ordinarily, of course, this court rejects attempts to inject an entirely new question at the merits stage. But we find it profitable to make an exception in this case, for while taking up Ms. Stanley's additional question reveals some problems with her pleading, it also highlights how Title I might provide relief for retirees like her. In addressing this additional question, we take as given the court's holding above that a plaintiff pursuing a claim under the ADA must plead and prove that she held or sought a job, and could perform its essential functions with or without reasonable accommodation, at the time of an employer's alleged act of disability-based discrimination. We take as given, too, that unlawful discrimination can take place at any one of 3 points in time: when a defendant adopts a discriminatory practice, when an individual is affected by application of a discriminatory practice, or when she becomes subject to such a practice. With all that in mind, we turn to consider whether Ms. Stanley's pleading states a claim. Start with the first option. Unlawful discrimination occurs when a discriminatory compensation decision or other practice is adopted. Here, Ms. Stanley alleges that happened in 2003, when the city revised its health insurance policy for employees who retire because of disability. At that point, her allegations show she was a qualified individual, working as a firefighter and able to perform the job's essential functions. The trouble for Ms. Stanley is that the ADA does not prohibit disability-based discrimination in the abstract. Instead, it bars an employer from discriminating against a qualified individual on the basis of disability. Discriminate against means treat worse, Muldrow v. St. Louis, and refers to distinctions or differences in treatment that injure protected individuals, Burlington N. and S. F. R. Company v. White. And Ms. Stanley's complaint provides no basis for inferring that the city's policy injured her in 2003. To the contrary, her complaint suggests that, when the city first issued its policy, she was not disabled and still expected to complete 25 years of service. So the first option is off the table for Ms. Stanley. Even so, it may be available to others who happen to be retired at the time they sue, if they can plead and prove they were both disabled and qualified when their employer adopted a discriminatory retirement benefits policy. Turn next to the second option. Unlawful discrimination also occurs when an individual is affected by application of a discriminatory compensation decision or other practice. Ms. Stanley alleges that happened to her in 2020, when her subsidized health insurance ran out. By then, however, she had been retired for 2 years, could not satisfy the requirements of her job, and was not seeking employment. So this option, too, cannot help Ms. Stanley. But, once more, it might help others who can show that they were affected by a policy change while they were qualified individuals, even if they happen to be retired by the time they bring suit. Now turn to the third option. Unlawful discrimination takes place when an individual becomes subject to a discriminatory compensation decision or other practice. This option might be especially promising for plaintiffs in Ms. Stanley's shoes. But, for reasons that take a little unpacking, it cannot form a basis for reversing the 11th Circuit's judgment in this particular case. Recall that Ms. Stanley's complaint does not allege what her disability is or when it emerged. As it happens, those facts came out later, after the district court dismissed her ADA claim, and after the parties proceeded to discovery and summary judgment on the remaining counts of her complaint. From this later developed record, it appears that Ms. Stanley was diagnosed with Parkinson's disease in 2016. The government argues that these later developed facts are sufficient to state a claim. After all, during the 2-year period between her diagnosis in 2016 and her retirement in 2018, Ms. Stanley was both an individual with a disability and a qualified individual who could still perform the essential functions of her job. During that critical window, too, the government submits, Ms. Stanley was subject to an allegedly discriminatory benefits policy that reduced her future retirement compensation. As promising as that theory may be, however, a number of case-specific problems prevent it from helping Ms. Stanley here. For starters, because this dispute comes to us on a motion to dismiss, we cannot look beyond the pleadings. And her complaint says nothing about the timing or nature of her diagnosis, nor does it allege that she worked for any period of time with a disability. To be sure, a court might, with a little more, draw a plausible inference that Ms. Stanley suffered discrimination between 2016 and 2018, Ashcroft v. Iqbal. So, for instance, if she had alleged that she developed Parkinson's disease before 2018, or that she worked for any period with some disability, then her case could likely proceed. But the complaint before us does not contain any of those facts. Even assuming we could overcome that problem, we would only face another. The 11th Circuit held that Ms. Stanley had affirmatively disavowed the government's theory. For support, the court pointed to Ms. Stanley's representation in her brief below that she did not claim she was impacted by the discriminatory city policy during her employment. To be sure, at oral argument Ms. Stanley told the Court of Appeals otherwise, and she attempted to adopt an amicus brief the government submitted to the 11th Circuit, advancing a theory much like the one it presses here. But applying its own rules of argument preservation, the 11th Circuit declined to pass on the government's theory because Ms. Stanley had not presented it to the district court and had specifically disclaimed it in her own brief on appeal. Complicating matters further yet, Ms. Stanley has not expressly asked us to address the 11th Circuit's preservation rules, nor has she asked us to reconsider our own general practice of allowing the courts of appeals to determine for themselves what arguments they deem properly before them. Exxon Shipping Company v. Baker, Singleton v. Wolf, Retirement Plans Com. of IBM v. Jander. So even if Ms. Stanley's complaint contains sufficient facts to sustain the theory the government now advances, and even if she had preserved that theory below, we would still face serious obstacles to reaching it. In saying as much, we stress that nothing we say today prevents future plaintiffs, or perhaps even Ms. Stanley herself in a future proceeding, from pursuing a theory along the lines the government proposes. It is simply that the theory cannot help Ms. Stanley in the present posture of this case. To sum up, we hold that, to prevail under the ADA, a plaintiff must plead and prove that she held or desired a job, and could perform its essential functions with or without reasonable accommodation, at the time of an employer's alleged act of disability-based discrimination. A variety of suits involving retirement benefits might well proceed under that rule. But, given how this particular case comes to us, we cannot say that the Court of Appeals erred in upholding the dismissal of Ms. Stanley's complaint. The judgment of the 11th Circuit is affirmed. It is so ordered. Justice Thomas, with whom Justice Barrett joins, concurring in part and concurring in the judgment. I join parts 1 and 2 of the Court's opinion. I write separately to express my concern with the increasingly common practice of litigants urging this Court to grant certiorari to resolve one question, and then, after we do so, pivoting to an entirely different question. This case exemplifies the problem. We granted review to resolve a circuit split regarding whether the Americans with Disabilities Act, ADA, permits suits by former employees who are no longer able to perform the essential functions of their jobs at the time of the alleged discrimination. For the first time at the merit stage, petitioner Karen Stanley urged us to decide a different question, whether Stanley could sue based on discrimination that occurred while she was still employed and able to work. But theory of liability was not passed upon below because the 11th Circuit determined that Stanley had disavowed it, and Stanley did not seek review of the 11th Circuit's issue preservation ruling. We ordinarily respect a lower court's application of its own preservation rules. I therefore would not opine on the additional question that Stanley raised for the first time in earnest at the merit stage. The ADA prohibits employers from discriminating against a qualified individual on the basis of disability in regard to the terms, conditions, and privileges of employment. The statute defines a qualified individual as someone who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. Stanley began working as a firefighter for the city of Sanford, Florida, in 1999. In 2016, Stanley was diagnosed with Parkinson's disease, and, in 2018, after 19 years of service, that disability forced her to retire early. When she retired, Stanley expected to continue receiving the city's health insurance subsidy until she turned 65. At the time of her hiring, the city's policy had been to pay a subsidy until age 65 to employees who retired after 25 years of service, as well as to employees who retired early because of disability. But, unbeknownst to Stanley, the city had changed its policy in 2003. Starting in 2003, the city paid the full subsidy for retirees with 25 years of service, but for those who retired earlier due to disability, it provided the subsidy for a maximum of 24 months. Stanley sued the city, alleging discrimination under the ADA. The district court understood Stanley to have alleged harm caused by discrimination that occurred after her retirement. In ruling on the city's motion to dismiss, the district court explained that to recover under the ADA, an individual must be a qualified individual at the time of the alleged discrimination. The district court determined that Stanley was not a qualified individual after her retirement, because she was not someone who could, with or without reasonable accommodation, perform the essential functions of the employment position that such individual holds or desires. Accordingly, the district court dismissed her claim. The 11th Circuit affirmed, reasoning that the ADA does not protect people who neither held nor desired a job with the defendant at the time of discrimination. In her petition for a writ of certiorari before this court, Stanley asked us to resolve an important and recurring question: whether an individual who no longer holds or desires his job may sue under Title I of the ADA for discrimination with respect to the post-employment distribution of fringe benefits. In other words, Stanley asked us to decide whether former employees who suffer post-employment discrimination can sue under the ADA. Stanley mentioned over 24 times in her petition that this question has divided the courts of appeals. In 2 circuits, Stanley explained, a plaintiff need not be a qualified individual, that is, someone who holds or desires the employment position at issue at the time of the alleged discrimination. In 4 other circuits, however, a plaintiff must be a qualified individual at the time that one is discriminated against to have the right to sue under the ADA. Stanley emphasized that this circuit split was dispositive in her case, as her suit was stymied by the 11th Circuit's determination that she wasn't a qualified individual at the time of the discrimination. Stanley described the circuit split as intractable, deep, well-recognized, and persistent. She also conveyed a sense of urgency, telling us that the circuit split is growing and unlikely to be resolved without this court's intervention. Stanley's emphasis on the circuit split was understandable, as it is no secret that circuit splits get our attention. Stanley also emphasized in her petition that the question dividing the courts of appeals is one of obvious importance. She conveyed that the circuit split matters for the 44 million Americans with disabilities whose rights under the ADA, until the split is resolved, may depend on their employer's zip codes. The persistence of the circuit split, she told us, means that disabled former employees only in certain parts of the country can vindicate their rights under the ADA. Stanley further assured us that this case would be a good one for resolving the circuit split. She told us that her case cleanly tees the issue up for this court's resolution as a pure question of law with no relevant factual disputes. She reiterated that point in her reply brief at the certiorari stage, telling us that this case is a clean vehicle with no impediments to settling the circuit conflict once and for all. We granted certiorari, adopting the question presented as framed by Stanley. I understood us to have taken the case to resolve the question that the circuits are split over, that is, whether the ADA permits suits by former employees who no longer hold or desire their job at the time the defendant engages in a discriminatory act. The 11th Circuit's position on that question was the basis for its ruling against Stanley below, and Stanley had asked us to take this case to resolve precisely that question. But something changed after this court granted certiorari. In her opening brief on the merits, Stanley told us that we need not even reach the Court of Appeals' erroneous holding that the ADA only prohibits discrimination against people who currently hold or desire a job. In other words, according to Stanley, we need not resolve the issue that the District Court in the 11th Circuit had decided. Instead, Stanley urged, we should decide a materially different question: whether Stanley could base her ADA claim on discrimination that allegedly occurred while she was still employed by the city. Specifically, Stanley contends that she suffered discrimination at some point after she was diagnosed with Parkinson's disease in 2016 but before she retired in 2018. Because Stanley held and desired to hold her job during this period, all agree that she was a qualified individual for at least some portion of that time. The 11th Circuit did not opine on the merits of this theory because it determined that Stanley had expressly disavowed it in her brief before that court. The court acknowledged that Stanley had attempted to raise this theory at oral argument, and the court acknowledged that the United States had raised this theory in its brief as amicus curiae, and that Stanley had attempted to adopt that amicus argument. But, applying its issue preservation rules, the 11th Circuit determined that Stanley had not properly presented this alternative theory. For the first time in her opening merits brief before this court, Stanley asked us to reconsider the 11th Circuit's application of its rules. She argued that nothing supports the assertion that she conceded her alternative theory below. In her view, she repeatedly argued in her 11th Circuit brief that she suffered discrimination while employed by the city. As I see it, Stanley's conduct amounts to a bait and switch. She urged this court to grant certiorari to resolve a circuit split on one specific legal question. After we agreed to resolve that question, she redirected us to a materially different question. I do not join Part 3 of the court's opinion because I would not opine on the merits of a new theory that Stanley did not develop at the certiorari stage. Redirecting this court's focus to an entirely new question at the merit stage is difficult to square with this court's rules. Our rules prevent us from reaching any question that is not fairly included in the question presented. Redirecting our focus to a different question is also highly disruptive to our deliberative process, as it often leads to a lack of adversarial briefing. We take seriously the need for adversarial briefing. The absence of briefing on the legal issue before us may complicate or even thwart our efforts to resolve it. Moreover, redirecting our focus to a different question has the effect of undermining this court's efforts to manage its merits docket. We receive thousands of petitions each year, and the vast majority of those petitions raise issues of deep importance to the parties involved in those cases. To use our resources most efficiently, we must confine our review to those cases that will enable us to resolve particularly important questions. If we were to entertain questions not presented in the petition for certiorari, much of this efficiency would vanish, as parties who feared an inability to prevail on the question presented would be encouraged to fill their limited briefing space and argument time with discussion of issues other than the one on which certiorari was granted. We have reached issues outside the question presented only in the most exceptional cases, when required by considerations of urgency or economy. I do not object to going beyond the question presented in such circumstances. But there is nothing exceptional about Stanley's case. To start, had she been more transparent at the certiorari stage, I doubt this court would have granted review of her alternative question. Stanley's new theory of liability is that she can base her ADA claim on discrimination that allegedly occurred while she was still employed by the city. To address that theory, however, we would first need to decide whether the 11th Circuit erroneously applied its own issue preservation rules and erred in concluding that Stanley had disclaimed this theory below. Stanley did not petition for review of the 11th Circuit's issue preservation determination. And I doubt that we would have agreed to review the fact-bound application of uncontested 11th Circuit precedents. Even if this court were willing to bypass the 11th Circuit's issue preservation determination, it is unlikely that we would have agreed to opine on the merits of Stanley's alternative theory in the first instance. Neither the District Court nor the 11th Circuit passed on whether Stanley could base her claim on events that occurred while she was still employed. That no court has decided this question is reason enough for us to decline to do so. We are a court of review, not of first view. We thus ordinarily wait to see if the crucible of adversarial testing, along with the experience of our thoughtful colleagues on the district and circuit benches, can yield insights or reveal pitfalls we cannot muster guided only by our own lights. In all events, our usual practice is to respect and leave undisturbed a lower court's issue preservation determination when that determination is not itself under review. I see no reason to depart from that practice here. Stanley asked this court to grant certiorari to resolve a discrete circuit split. After we agreed to do so, she asked us to resolve an entirely different legal question. I do not find it profitable to reward Stanley's bait and switch in these circumstances. I encourage litigants before this court to remain focused on the questions presented in the petition for a writ of certiorari, and only those questions, after this court grants certiorari. Redirecting us to a different legal question at the merits stage can be disruptive, inefficient, and unfair to all involved. Of course, Stanley is not the first litigant to resist the question presented before this court. I hope, however, that this court and future parties will take seriously the obligation to adhere to the question presented. Justice Sotomayor, concurring in part and dissenting in part. I join parts 3 and 4, except footnote 12, of the dissent because, in my view, Title I's prohibition on disability discrimination does not cease the day an employee retires. As Justice Jackson explains, when an employer makes a discriminatory change in post-employment benefits that a retiree earned while qualified and employed, the employer discriminates against the person in her capacity as a qualified individual. Because the court eschews that common-sense understanding of the statutory text, I also respectfully dissent in part. Notwithstanding the court's error on that question, at least 5 justices, 4 in the plurality and Justice Jackson in dissent, agree that plaintiffs in Lieutenant Stanley's shoes can plead disability discrimination if they were subject to a discriminatory compensation decision or other practice, while a qualified individual within the majority's understanding of that term. That remains true even if the employee does not file her lawsuit until after she retires, as long as she was subject to a discriminatory policy while both disabled and a qualified individual. There is good reason to think that Stanley herself was subject to the allegedly discriminatory policy at issue here while she was both disabled and employed. Yet I ultimately agree with the plurality that this theory cannot form a basis for reversing the 11th Circuit's judgment in this particular case, especially because Stanley herself did not ask this court to review the 11th Circuit's holding that she had forfeited this theory before that court. Because Part 3 nevertheless makes clear that Title 1 may well provide relief for retirees like Stanley, I join that portion of Justice Gorsuch's opinion. Justice Jackson, with whom Justice Sotomayor joins as to Parts 3 and 4, except for footnote 12, dissenting. Retirement benefits are essential building blocks of the American dream. Workers typically earn these benefits on the job and reap the rewards after leaving the workforce. Congress has long understood that, by enabling workers to retire with dignity, independence, and security, retirement benefits are a critical aspect of job-related compensation. Thus, no one seriously disputes that the Americans with Disabilities Act of 1990, ADA, prohibits disability discrimination with respect to retirement benefits. Unfortunately, however, by viewing this case through the distorted lens of pure textualism, the court misperceives those protections today. As I understand today's holding, The court has decided that if a worker who has earned retirement benefits leaves the workforce, as expected, and is then discriminated against with respect to the provision of those earned benefits because she is disabled, Title I offers no protection. To get to this counterintuitive conclusion, the court relies on Title I's qualified individual definition, a provision designed to protect employers from having to employ those who cannot do the work, not to cut off the rights of those who already finished it. Making matters worse, the court has to extend itself to reach this stingy outcome, because the case before us does not present a scenario involving discrimination that took place only post-employment. In short, the court overlooks both the actual facts presented in this case and the clear design of the ADA to render a ruling that plainly counteracts what Congress meant to, and did, accomplish. I respectfully dissent. Congress passed and President George H.W. Bush signed the ADA into law 35 years ago. This landmark legislation's overarching aim was to assure equality of opportunity, full participation, independent living, and economic self-sufficiency for the millions of Americans with disabilities. Thus, Congress designed the ADA as a comprehensive national mandate for the elimination of disability discrimination that would provide clear, strong, consistent, enforceable standards addressing discrimination against disabled Americans. Title I of the ADA prohibits disability discrimination in the employment context. It protects against disability discrimination with respect to the provision of, among other things, fringe benefits, employee compensation, and other terms, conditions, and privileges of employment. Section 12112A sets forth Title I's general prohibition, which states, "No covered entity shall discriminate against a qualified individual on the basis of disability in regard to job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment." Section 12112B then provides specific examples of discrimination that Title I prohibits. As the ADA made its way through Congress, employers worried that the bill would require them to hire and retain individuals who, even with reasonable accommodations, could not satisfy a job's demands. Title I's qualified individual provision was Congress's response to that concern. Congress inserted the qualified individual phrase into Title I's general prohibition, and it elsewhere defined a qualified individual as one who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. The point of inserting this definition and relying on it in the ADA was simply and solely to reaffirm that Title I does not undermine an employer's ability to choose and maintain qualified workers. Today, however, the court takes Title I's qualified individual definition out of context and assigns it an additional function, to act as a strict temporal limit on the reach of Title I's protections. That is, the court reads the qualified individual provision to mean that only those who hold or desire a job when alleged discrimination occurs can claim Title I's protection. It is on that ground that the court concludes that Lieutenant Karen Stanley, a now retired firefighter suffering from Parkinson's disease, cannot make out a Title I claim against her former employer for assumed disability discrimination relating to retirement benefits that she earned in the line of duty. In my view, for the reasons explained below, the court is wrong twice over. It should not have used this case to make any pronouncements about the viability of a Title I discrimination claim that arises after an employee retires. And it misreads Title I to introduce a time-related limitation that appears nowhere in the statute Congress wrote. Because this case arises from a Federal Rule of Civil Procedure 12b, 6, dismissal of Lieutenant Stanley's complaint, we are required to accept as true all the factual allegations in her complaint. We must also assess Lieutenant Stanley's complaint as a whole, credit all plausible allegations, and draw reasonable inferences in her favor. Like the majority, I will start by assuming that what Lieutenant Stanley alleges to be discriminatory conduct by the city of Sanford, Florida, the city, in fact violated the ADA. Doing so, what follows are the facts. Lieutenant Stanley was employed as a firefighter by the Sanford Fire Rescue Department for just shy of 2 decades. She started in 1999 and was promoted to lieutenant in 2005. Lieutenant Stanley remained continuously employed in that position until November 2018. When she was forced to take disability retirement due to her physical disability. Notably, while Lieutenant Stanley was still employed, the city changed its disability retirement policy. At the time Lieutenant Stanley was hired, the city's policy was to pay for disabled retirees' health insurance until retirees turned 65 years old. In 2003, the city changed that policy to offer a maximum of 24 months of healthcare coverage for disabled retirees. This change meant that Lieutenant Stanley was subject to the new policy from 2003 onward, including the period from when she became disabled, while she was still employed, until she retired. Lieutenant Stanley's complaint alleges that the city's taking away of the prior disability insurance policy denied disabled retirees like her equal access to health insurance. She further alleges that the new 24-month coverage policy violates the ADA in and of itself. All agree that, under the Lilly-Ledbetter Fair Pay Act, an unlawful employment practice occurs when a plaintiff becomes subject to a discriminatory compensation decision or other practice. Based on the facts Lieutenant Stanley alleges, the Fair Pay Act framework supplies the answer to the question presented in this case. Before retiring, Lieutenant Stanley had a disability, was a qualified individual who performed the essential functions of her job despite that disability, and was subjected to an allegedly discriminatory policy based on her disability, insofar as the city changed its retirement benefits package in a manner that disadvantaged disabled retirees. Thus, it made no sense for the city to argue for dismissal of Lieutenant Stanley's ADA claim, as it did, on the ground that she was not a qualified individual at the relevant time. On the facts as alleged in her complaint, the city subjected Lieutenant Stanley to the discriminatory policy during her employment, not only after she retired. So, Lieutenant Stanley was performing the essential functions of her job at the pre-retirement point at which she became disabled and was subjected to the new policy. This made her a qualified individual, notwithstanding the city's counterfactual contention. The court has decided not to resolve this case on that straightforward ground. A plurality of the court says, instead, that case-specific problems prevent those facts from helping Lieutenant Stanley here. Even setting aside the plurality's failure to accept Lieutenant Stanley's plausible factual allegations and to draw reasonable inferences in her favor, I disagree with its analysis of the case-specific problems. In my view, none of the plurality's concerns precludes this court from resolving this case based on the factual allegations in Lieutenant Stanley's complaint. First, the plurality says Lieutenant Stanley's complaint does not allege her diagnosis, its timing, and whether she had the disability while she was still working. But her complaint tells us that she had a disability and eventually had to retire because of it. This is enough to draw a plausible inference that she worked with a disability and was thus subject to the discriminatory policy some time before retiring. Second, the plurality claims that, in the proceedings below, Lieutenant Stanley affirmatively disavowed the argument that she was discriminated against while still working. Not so. All she said was that she did not claim she was impacted by the discriminatory city policy during her employment. But whether someone was impacted, affected, by a policy is distinct from whether they were subject to it. Third, the plurality contends that, in applying its own rules of argument preservation, the 11th Circuit declined to pass on Lieutenant Stanley's theory that she was discriminated against during her employment, and that this court did not grant certiorari to decide whether that assessment was correct. But Lieutenant Stanley's theory was merely a response to the city's argument that her complaint failed to state a claim. Moreover, the allegation that the relevant discriminatory act took place while she was still on the job tees up the question we did grant certiorari to address. Under the ADA, does a former employee, who was qualified to perform her job and who earned post-employment benefits while employed, lose her right to sue over discrimination with respect to those benefits solely because she no longer holds her job? Lieutenant Stanley maintains that she states a claim for discrimination under the ADA with respect to retirement benefits she earned while working despite the fact that she no longer holds the job. The question presented neither states nor suggests that the employer's act of discrimination took place only after Stanley retired. And, to the extent such timing is even relevant, answering the question Lieutenant Stanley actually presented in light of her contention that the discrimination occurred while she was still working is the only framing that is actually consistent with the facts alleged in Lieutenant Stanley's complaint. What is more, our traditional rule is that once a federal claim is properly presented, a party can make any argument in support of that claim. Parties are not limited to the precise arguments they made below. And, here, nobody disputes that Lieutenant Stanley preserved the claim that the city discriminated against her in violation of the ADA by changing her retirement benefits. Lieutenant Stanley's contention that she was subject to the allegedly discriminatory policy while she was still an employee is, at most, a new argument to support what has been her consistent paradigm. If the traditional rule applies anywhere, it should be in a case of this nature. This claim was brought by a disabled firefighter suffering from Parkinson's who has consistently maintained that the city's change to its retirement benefits policy, implemented while she was an employee, discriminates against disabled beneficiaries. If we extend leniency to professional advocacy organizations when they craft allegations, it seems only fair to extend that same grace to those with limited resources to game out long-term litigation strategies. Moreover, it bears noting that this case comes to us on review of a complaint, which need only plead facts sufficient to support a claim, not comprehensive legal theories. If we were reviewing a summary judgment or trial record developed on Lieutenant Stanley's district court legal theories, the plurality might have a point. But, at the pleading stage, A legal claim rises or falls based on the facts, not theories, alleged. If all that were not enough, the case record here establishes that Lieutenant Stanley tried below to make the point that the discriminatory act she was complaining of occurred during her employment, once the city made timing an issue. For instance, Lieutenant Stanley's opening brief to the 11th Circuit incorporated the government's amicus brief, which argued that, contrary to what the city had asserted, Lieutenant Stanley had suffered the alleged discrimination while employed. Lieutenant Stanley and the government also made this point repeatedly to the 11th Circuit at oral argument. It is true that, instead of accepting the facts as Lieutenant Stanley alleged them, and as the federal rules and our precedents require, the 11th Circuit rejected Lieutenant Stanley's and the government's attempts to set the record straight about the timing question. But it is odd, to say the least, that Lieutenant Stanley is now being penalized for her thwarted earlier attempts to assert that the city's discriminatory actions occurred while she was still an employee, especially when she might have been able to make that point here if she had skipped saying this to the 11th Circuit entirely and had pointed it out to us in the first instance. Regardless of how the 11th Circuit handled the allegations in this case, in my view, we need to remember that our court's role is to decide what the law is for the entire nation. That reach carries with it the heightened responsibility to tether the legal principles we pronounce to the facts of the case before us, lest we not only create unfairness for particular parties but also allow a poor vehicle to drive us, and the law, astray. Considering questions of law divorced from the actual facts raises doubts about our authority under Article 3. It also risks error, because it is far more difficult to correctly address legal issues on facts that do not implicate the question presented. The discrepancy between real life and our legal decision-making matters in concrete and demonstrable ways. A retiree who alleges disability discrimination that first occurs only after they have retired is in a materially different position from one who was subjected to that same discriminatory action during her employment. Whether or not Title I covers that circumstance does not answer whether a plaintiff like Lieutenant Stanley, who did not suffer a retroactive change to her terms and conditions of employment, but was instead subjected to the allegedly discriminatory policy while employed, can sue. When we realize that Lieutenant Stanley's case does not present a circumstance of discrimination that occurs only after one's employment ends, we had two reasonable options. We could have applied our traditional rule, allowing Lieutenant Stanley to make all arguments in support of her claim, and then considered how the alleged facts of her case fare under the law as we understand it. Alternatively, we could have dismissed the writ of certiorari as improvidently granted and awaited a true case of post-employment discrimination to decide that question. Instead, the court chooses door number 3, to close its eyes to what Lieutenant Stanley actually alleges and use her case nonetheless to answer an important legal question that does not arise from the facts in her complaint. Thus, in this of all cases, the court abandons its considered practice not to decide abstract, hypothetical or contingent questions. I think plowing forward to make new pronouncements of law when the alleged facts do not implicate the rule we are announcing is a mistake. That Lieutenant Stanley suffered discrimination during her employment is not a disposable theory. It is the only lens through which we can accurately and properly view her case. The second misstep that the court makes in this case is to construe Title I of the ADA to allow employers to engage in post-employment discrimination. The text of the statute itself says nothing, zero, about the pre-employment or post-employment timing of an act of disability discrimination. Nevertheless, the court homes in on one isolated provision, the qualified individual definition, detaches it from its place in the overall scheme, and converts it into a strict limitation on the temporal reach of Title I's protection. In my view, settled law requires a different path. We should have followed the method this court employed when it addressed a comparable question of statutory interpretation in Robinson v. Shell Oil Company. There, we held that employees in Title VII covers former employees. To reach that conclusion, we analyzed the text, context, and purposes of the provisions at issue. Applied here, those indicators confirm that Title I prohibits disability discrimination in the post-employment payout of benefits earned during an employee's tenure. Robinson first says to consider whether the statute's text supplies a plain and unambiguous answer to the question of what the statute allows. The inquiry must cease at text alone only if the statutory language is unambiguous and the statutory scheme is coherent and consistent. Title I's text and overall scheme do not foreclose, much less unambiguously so, retirees' ability to sue over discrimination in the post-employment payout of benefits they earned on the job. Consider first what Title I's text does not say. Title I does not categorically exclude former employees or retirees from the ADA's protection, nor does it explicitly carve out post-employment discrimination as non-actionable. Nothing in the statute actually says that one must currently hold or desire a job to obtain protection from the forms of disability discrimination that Title I prohibits. And Title I does not place a temporal limit on the reach of its protections. What the text of Title I does plainly convey is broad protection for workers against disability discrimination with respect to job-related benefits. Section 12112A's general prohibition bars disability discrimination in regard to both employee compensation and other terms, conditions, and privileges of employment. Section 12112B, 2, also specifically prohibits disability discrimination by an organization providing fringe benefits to an employee of the covered entity. As I explain in Part 4, Infra, those terms capture deferred compensation that workers earn during employment and then receive during retirement. So where does the majority find its purported temporal limit on Title I's protections? Almost exclusively in the statute's qualified individual definition. Recall that Section 12112A prohibits disability discrimination against a qualified individual, which Section 12118 defines as an individual who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. Based on the text and tense of this provision, the majority concludes that Title I offers no protection to an individual who does not presently hold or desire a job. It reaches that result by reading the qualified individual definition to apply equally to two scenarios. The first scenario is where someone seeks to keep or obtain a job, but finds that aspiration stymied by disability discrimination. The second scenario is where someone previously had a job, for which they were qualified, but suffers post-employment discrimination in the payout of job-related benefits. The false equivalence of these two very different scenarios fuels the majority's effort to sustain a textualist case for a temporal limitation. But nothing in the text compels it. It is perfectly permissible to read the qualified individual definition as setting a conditional mandate. If a plaintiff relies on Title I regarding a job she seeks to obtain or hold, then she must be able to perform the essential functions of that job. Conditional mandates like this appear in daily life. Imagine seeing a sign that reads, "To live in this apartment building, you must be able to clean up after the pets that you own." No one would read that rule as requiring tenants to own pets. Rather, it is a conditional mandate that applies if tenants have pets. Read that way, the qualified individual mandate operates to protect employers from having to extend employment to those who cannot do a job. It says nothing about the time at which the alleged discrimination must occur relative to one's period of employment. The majority runs in a series of textualist circles, attempting to find the explicit temporal limit it seeks in the qualified individual definitions text. But it comes up short of anything to confirm that the qualified individual definition is an expression of Congress's temporal limit on all of Title I. And the reality is that Title I's text contains neither an express prohibition against nor authorization for retiree lawsuits challenging post-employment discrimination. Because text alone does not supply an unambiguous answer, Robinson's framework tells us to proceed to understand the context in which the qualified individual definition appears in Title I, as well as the point of that provision, i.e., what, exactly, Congress designed that definition to do. Congress incorporated the qualified individual provision into Title I of the ADA to address a particular problem. Its legislative history makes clear that, by adding this provision, Congress simply intended to reaffirm that Title I does not undermine an employer's ability to choose and maintain qualified workers. Congress was responding to businesses' concerns that protecting disabled workers would mean requiring employers to hire employees whose disabilities could threaten the health or safety of others, damage property, or prevent the completion of the work. Could a jewelry store in search of a security guard require mobility and dexterity from an applicant? Or, if a job involved lifting 50-pound boxes, could an employer require applicants to be able to lift that much weight? Congress added the qualified individual provision to make clear that the answer to these and similar questions was yes. It explained that, as with other civil rights laws prohibiting discrimination in employment, Title I would not limit the ability of covered entities to choose and maintain a qualified workforce. Employers could hire and employ employees who can perform the job and use job-related criteria in making those determinations. In other words, Congress designed the provision to ensure that employers can continue to require that all applicants and employees, including those with disabilities, are able to perform the essential, i.e., the non-marginal functions of the job. The qualified aspect of Title I's protection thus recognizes that, in certain situations, employers may lawfully discriminate against applicants and current employees based on disability. Specifically, employers may do so if disability renders someone unable to perform the essential functions of a job that she holds or desires. And that makes perfect sense when a plaintiff seeks Title I's protection with respect to hiring, promotion, or firing determinations. A retiree seeking to remedy discrimination as to the payout of benefits already earned on the job, by contrast, does not trigger the concerns that motivated Congress to craft a qualified individual metric. Unlike allowing disability discrimination against someone who is or seeks to be in the workforce but cannot do the job, Authorizing disability discrimination against a retiree who is in the workforce, but has now left it, has nothing to do with the problem Congress was addressing when it imposed the conditions in the qualified individual definition. The long and short of it is that the qualified individual provision's function is to protect employers from having to hire and maintain employees who cannot do the work. That provision is not designed to serve as a temporal limit that extinguishes the rights of those who already did the work and have now left the job. Nor does it make any sense, given Title I's overall scheme, for the qualified individual provision to moonlight as such a temporal restriction. If Congress had wanted the qualified individual definition to do the work of cutting off discrimination claims that arise after retirement, it easily could have said so. It is clear, then, that the majority has commandeered Title II and used it to steer today's legal analysis through wholly inapposite terrain. Doing this not only diverges from Congress's design but also leads to anomalous results. That is, even as the majority assumes that Title I protects retirement benefits, it adopts an interpretation that severely undermines those protections, rendering them null just when they matter most. Worse still, the majority's reading of this statute counteracts the objective of the qualified individual provision, the very provision on which the majority's holding turns. Under the majority's logic, if an employer cuts off an employee's entitlement to retiree health benefits because of their disability, one day before they retire, the employee can sue. But if the employer waits until one day after that employee's retirement, assuming the employee no longer desires the job they held, Title I offers them no protection. Imagine a janitor who is deaf. She works decades at a school, performing all essential functions of her job. During that time, she earns retirement benefits, including post-employment health insurance and a pension. After she retires, the school cuts off her employer-provided retirement benefits on the ground that it was always a nuisance to have to accommodate her all those years because of her deafness. Does Title I protect her against this blatant disability discrimination? Per today's holding, the majority says no. Even though the school has taken away job-related benefits that the janitor earned during her working years, she is out of luck because, the majority reasons, Title I's protections are limited only to those who hold or desire a job. Arbitrariness abounds. If the retired janitor remains able to perform the essential functions of her job, and if she still wants to work, then she can bring a Title I suit to challenge the school's discrimination in the payout of retirement benefits she already earned. But if she can no longer perform the essential functions of her job, or if she simply no longer desires a job, then she cannot. But why would Congress hinge the retired janitor's protection against discrimination in the benefits she earned while working on whether she wants and can perform a job in the future? While she was working, she could perform the essential functions of her job and thereby earned the benefits in question. Isn't that what matters in any coherent and consistent scheme designed to protect against disability discrimination? It is illogical to conclude that, while Congress wanted to protect against discrimination with respect to retirement benefits, it crafted a statute that implicitly cuts off those protections the moment a worker last clocks out. Holding as much allows employers to evade Title I's retirement benefit protections by bait and switch. They need not refrain from discrimination. All they have to do is wait. Rather than unfastening the qualified individual definition from the objective that compelled it and construing that provision to limit the broad protections that the ADA confers, I would adopt the statutory reading most consistent with the overall design of Title I. Congress passed the ADA to protect people with disabilities, and it crafted Title I, in particular, to provide disabled workers with meaningful protections against disability discrimination in the provision of job-related retirement benefits. To properly evaluate the intended scope of Title I's protections, courts need to situate its provisions within that broader context. At our best, this court has appreciated the ADA's broad mandate and sweeping purpose for remedying widespread discrimination against disabled individuals. We have called the statute's comprehensive character one of its most impressive strengths, and we have seen it as Congress designed it, a milestone on the path to a more decent, tolerant, progressive society. Reading Title I to prohibit post-employment discrimination in the provision of retirement benefits, as I do, aligns with the broader purposes of the ADA. Retirement benefits are an essential aspect of the equality of opportunity, full participation, independent living, and economic self-sufficiency that the ADA promotes. They are also one of those opportunities for which our free society is justifiably famous, and Congress wanted to ensure that disabled Americans could enjoy them too. In other words, Title I's protections encourage disabled Americans to enter the workforce and have an equal opportunity to earn all that a good job brings to workers and their families. Retirement benefits are a key piece of that pie. After all, workers often decide whether to enter the workforce, and when to leave, based on the terms of such benefits. Protecting disabled Americans' right to receive all that they earn during their working years, free from disability discrimination in retirement, is essential to a faithful application of Congress's handiwork. The majority skips past these anchoring objectives. It hastily assumes Congress wanted to confer protection against job-related disability discrimination, to include discrimination related to the provision of retirement benefits, but then treats the many provisions of the ADA that demonstrate this congressional purpose as irrelevant to an interpretation of Title I's reach. In my view, Congress's clear aims are not so easily avoided. A comprehensive look at Title I reveals its protection of retirement benefits in at least 3 places. Section 12112A's general prohibition bars disability discrimination in regard to both employee compensation and other terms, conditions, and privileges of employment. Additionally, Section 12112B, 2, prohibits disability discrimination by an organization providing fringe benefits to an employee of the covered entity. Legislative history reinforces that Congress inserted these phrases into Title I to protect pensions, health insurance, and other benefits that employers promise to give their employees upon retirement. Congress also crafted Title I knowing that courts had construed these terms in similar statutes to include retirement benefits. This court had held, for example, that a benefit need not accrue before a person's employment is completed to be a term, condition, or privilege of that employment relationship. It had thus made clear that pension benefits qualify as terms, conditions, or privileges of employment even though they are received only after employment terminates. 5 justices had also reasoned that there is no question that the opportunity to participate in a deferred compensation plan constitutes a condition or privilege of employment, and that retirement benefits constitute a form of compensation. And the court had further clarified that a benefit that is part and parcel of the employment relationship may not be doled out in a discriminatory fashion. This backdrop highlights not only that Congress viewed retirement benefits to be a protected form of employee compensation, but also how Congress intended for this particular form of protection from disability discrimination to operate. To be specific, retirement benefits are not payments to retirees for something they do post-employment, i.e., when they neither have nor desire a job. Rather, as we held in an analogous context just before the ADA's passage, retirement benefits are deferred compensation for past years of service rendered. Thus, as we recognized in Davis, although workers receive these benefits after they retire, workers earn these benefits as employees during their employment. If an employer alters the payout of benefits based on an employee's disability after that individual's employment ends, say, by reducing pension benefits, the employer has discriminatorily changed the terms and conditions of employment that the individual was subject to while working. The retiree earns those benefits as an employee. Therefore, the post-employment adverse action retroactively discriminates against that previously qualified individual. So, even assuming, as the majority does, that the individual's qualifications are apposite to this particular scope of coverage question, but see Part 3, A, supra, the individual could perform the job's essential functions when it mattered, when the individual earned the benefits. The government proffers an illustrative hypothetical. Imagine a statute prohibiting airlines from discriminating against a qualified passenger in the terms, conditions, or privileges of carriage, and defining a qualified passenger to mean someone who meets the carrier's eligibility requirements for the flight on which the passenger is flying or seeks to fly. What happens if the airline discriminates against the individual in the handling of their baggage at their destination, after they debark? The majority would say, too bad, the individual is no longer a qualified passenger. But I would read the statute in context, as the government does. The individual was qualified during the relevant period. The discrimination relates to their act of flying with the airline as a passenger. And this is the type of discrimination that the statute was designed to stop. This reading follows from the text, context, and primary purpose of the statute. It renders the provision in question part of a coherent and consistent overall scheme. So it is here. A retiree who worked and earned benefits as a qualified individual, then suffered discrimination at the payout stage for those benefits in retirement, is covered by Title I's protections. On such facts, fairly interpreted, the employer has discriminated against a qualified individual, in regard to employee compensation. That is precisely what Title I prohibits. Waving off Congress's broader objectives, the majority notes that legislation does not pursue its stated purpose at all costs. This common rejoinder attacks a straw man. Looking to a statute's purposes helps us to understand, not override, that statute's text. And while legislators may not pursue their purposes at all costs, such calibrations and the compromises they reflect do not make legislative purposes irrelevant to a full and fair evaluation of what a statutory provision means, as the majority suggests. Too often, this court closes its eyes to context, enactment history, and the legislature's goals when assessing statutory meaning. I cannot abide that narrow-minded approach. If a statute's text does not provide a clear answer to a question, It is not our role to keep twisting and turning those words until self-confirmatory observations solidify our first blush assumptions. Courts should remember that legislation has an aim. It seeks to obviate some mischief, to supply an inadequacy, to effect a change of policy, to formulate a plan of government. Viewing a statute's text in light of its aims allows us to carry out Congress' likely intent in enacting the statutory provision before us. Crucially, this keeps us to our proper role as judges in a democratic system. Here, instead of rendering Title I's retirement benefit protections an empty promise by adopting a reading destructive of its purpose, the court should have adopted the reading that is not only plainly text-based, but is also more consistent with the broader context of Title I and the primary purpose of its protections. In my view, in the absence of any clear temporal limitation on the scope of Title I, the best interpretation would permit those who were qualified enough to earn benefits while working to seek a remedy for post-employment discrimination in the payout of those benefits. Disabled Americans who have retired from the workforce simply want to enjoy the fruits of their labor free from discrimination. Congress plainly protected their right to do so when it crafted Title I. Yet, the court ignores that right today. It reaches out to cut off post-employment protection against disability discrimination in a case that does not require us to decide that question, seizes upon the inapposite text of the qualified individual definition, and converts that text into a temporal limit it was never designed to be. Worse still, by doing all this, the court renders meaningless Title I's protections for disabled workers' retirement benefits just when those protections matter most. It is lamentable that this court so diminishes disability rights that the people, through their elected representatives, established more than 3 decades ago. Even so, there is hope for a legislative intervention to fix the mistake the court has made. Americans with disabilities have proven time and again that they can overcome long odds in fighting for their own equality. When that happens, my one wish would be for this court to stay out of their way. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.